Good afternoon, everyone. Thank you for joining us today, and welcome to the second part of Denton's three-part seminar about risk management strategies for your cannabis business during COVID-19 and beyond. Today, we'll be discussing contractual obligations, and specifically what every cannabis company needs to know about force majeure and related concepts in the current unprecedented landscape. This is a particularly timely seminar, as many provincial governments have begun the gradual, staged, and regional approach towards reopening business. My name is Arabas Majin, and I'm a senior associate in the firm's litigation and dispute resolution group in Toronto. My practice involves a variety of corporate, commercial, and civil litigation matters. I have particular experience in cases involving product liability, competition law, class actions, and cannabis in Canada. I'm joined by my two colleagues, Tom O'Leary and Erica Shadid. Tom is a partner in the firm's litigation department in Calgary. With over 2 decades of experience, Tom has acted as lead counsel in numerous commercial, financial, and energy-related matters. Tom is a proponent of alternative dispute resolution and regularly finds creative solutions to some of our clients' most challenging disputes. Tom will be speaking to us today about the doctrine of force majeure and related concepts such as frustration of contract. Erica is an associate in the firm's litigation group in Montreal. She has a broad practice with significant experience in class actions, consumer protection, regulatory matters, and professional liability. Erica regularly advises clients about issues involving marketing and advertising in both traditional and digital media. Erica will provide us with some advice about force majeure in Quebec's civil law tradition. With that being said, I'd like to turn things over to Tom.
Thanks, Era, and thanks everyone for joining us. Era gave you a bit of a background of who I am and what I do. Most of what I do in terms of commercial disputes relates to contracts and contractual terms. And I've been, I guess it's timely, but coincidental that I've wound up writing and presenting pretty extensively on force majeure over the last decade or so, as well as other contractual issues. So I hope I can give you some tips and some good perspective on what to expect and what to look for in the field of force majeure, along with Erica, who will deal with the particularly Quebec nature of that doctrine. I know only the generalities, that it is a young industry and it has the characteristic features of any young industry, and that the financial stability across the industry is inconsistent. And that the supply chains within the industry are evolving fairly rapidly and not always as secure as they might be in a more mature industry. So these factors make the cannabis industry, should make the cannabis industry a little bit more susceptible than a mature industry might be to claims of force majeure and other items that might interfere with the ability of players in the industry to meet their contractual obligations. Just as an aside, reading the business section, one will often see mention of how some cannabis companies may be struggling financially, and those actors might be tempted in some cases to seek relief from force majeure to relieve themselves, at least temporarily, from a bad bargain. And that's a caution that others in the industry should probably be taking. Anyway, in any event, that susceptibility of the cannabis industry to these types of incidents and claims is, I think, all the more obvious with our recent COVID-19 pandemic and the impacts that has had and is going to continue to have for the next little while at least. So what is force majeure? It's translated as superior force. It is a purely contractual doctrine under the common law. That is, Quebec is somewhat different, as Erica will mention, but in terms of outside of Quebec, it's a purely contractual issue. There's no restrictions on what a contract can define as force majeure or what impacts or effects it can specify from a force majeure event. That being said, force majeure is a type of contractual clause that is meant to respond to specific types of incidents. There are very regular presence in commercial contracts. Many of you have probably seen a number of different force majeure provisions. The idea behind them is to provide temporary relief in a black swan type of event, something that is unforeseen, uncontrollable, and that prevents performance of obligations by one party. And the obligations of that party under a force majeure concept can be suspended until whatever the causative event can be ends or can be overcome somehow. So these clauses are often at the back of contracts and have traditionally been treated as boilerplate in many cases. With the events of the last 6 months or so, that treatment is likely to change, and they're getting a lot more attention from all sorts of commercial actors as well, inevitably as the courts. They've been around for a couple of 100 years, and the origin gives you a bit of a clue as to the types of events and the types of strictness that go with interpreting the force majeure clause. It was really a response to a common law doctrine of frustration. And frustration is a doctrine that allows the contract to be terminated completely when the object or its purpose is destroyed. The classic case is an Old English case, as they all are, it seems, of an opera that was scheduled, and the opera house burned down before the day before the opera singer was to appear. And that was viewed as something that would frustrate completely the contract, and it's over with the chips falling where they may. And the harshness of the doctrine of frustration really is twofold. One, it's extremely, extremely narrow in its application. The threshold of the entire object of the contract being destroyed is an extremely high one. And secondly, once a frustrating event occurs, the chips fall where they may. That is, the opera singer probably got paid in advance and didn't have to give back the money. So can be a very harsh doctrine in terms of its impacts on the parties. And so contractual drafters in response thought, well, we need something to address this type of incident, but where the incident's not permanent but only temporary, and to allow the parties to continue on with their contractual relationship and not have these kinds of harsh results, or at least mitigate them. So a typical force majeure clause tries to address those types of issues, and we really have 4 elements that are up on the slide. Typical elements. First would be the triggering event will be defined. This is often done, if you've reviewed any of these, as a laundry list of things like acts of God, labor disturbance, loss of market, and usually with a basket clause at the end, which will say something to the effect of, or any other event beyond the control of the impacted party. Pandemics are rarely listed as force majeure events, or have not been listed very often as force majeure events, but again, that's, I'm sure, something that will change, and they will be included going forward, because they do see this pandemic seems subject to the impacts it might have, seems to be just the type of event that seems likely to qualify as a force majeure event under the basket clause, as something beyond the control of any particular party. Some force majeure clauses are a bit briefer, and they really only contain the basket clause type of criteria. While every case is unique, generally the basket clause is the governing governing principle to whether one of the aforementioned events will qualify as force majeure. So first thing's triggering event. The second thing that typical clause will address is what is the threshold of force majeure? The traditional threshold is the prevention of performance. However, parties can define the threshold differently. In English contracts, the wording that's often used is prevent or hinder performance. And hinder in that sense will usually mean a limitation, a forced limitation on performance. That is, if you undertake to deliver 100 units, but force majeure restricts you to 50, that would be a hindering of performance. Though there are also cases that define hindering as somewhat more broad and try to introduce elements of reasonableness and that sort of those sorts of elements. That's a little less common in Canada, but the law is no less clear in Canada, unfortunately, on what that might mean. The third usual element is a notice provision. It's generally thought if one party is going to claim force majeure, the other party has a right to know. And so those can be detailed or general, but strict compliance with them is required in almost all cases. So that's something to take away. And the third is mitigation. And this is often where, and I suspect going forward over the next couple of years in the wake of COVID, where most of the dispute action will be, if I can refer to it that way, is what is the standard once a triggering event has occurred? What's the standard of mitigation that the claiming party has to abide by? That is, does the claiming party have to find an alternate supply of product if that was their contractual obligation, was to deliver that product? Are there financial limitations on what mitigation must be undertaken? The question often comes up, and in those respects, in those two dynamics, that is, do we have to find alternative supply, or do we have to spend ourselves into bankruptcy to mitigate this event? There's not a lot of great case law on it, unfortunately, and therefore we will usually recommend that parties define in some sense the limits of their mitigation obligations. Sophisticated contracts in the oil and gas shipping sphere and marketing sphere, I know, tend to impose a limitation in terms of financial impact. Material financial impact is a phrase that's used in one of the standard forms. And so you may see those kinds of limitations as well. Otherwise, there's a great deal of uncertainty as to what mitigation is necessarily going to be required. Is it just the event, and is it the impacts of the event? And if so, to what degree? So if I can ask Ara to turn to the next slide. Courts have a pretty strong, in the common law Canada, have a pretty strong resistance to letting parties escape contractual obligations. That reluctance is manifested in the doctrine of frustration, which I mentioned earlier, the very high threshold to trigger that, but also in how force majeure clauses tend to be construed. Always subject to the clear wording of the contract, providing for something different. The triggering event must generally be something that was unforeseen and beyond control. Foreseeability is probably the tricky concept there, as I've seen some commentators wonder if the fact of a pandemic occurring now will make the next pandemic, whether it's 10 years or 100 years, will make it foreseeable to contracting parties, and thus beyond the scope of force majeure. So that's a concept to to keep in mind. Most of the drafting recommendations you might see in these types of presentations will suggest making sure that you don't use the word foresight or the concept of foreseeability in the clause itself, because it adds that extra level of strictness and to some degree, I think, unpredictability too. A second presumption flowing from the court's reluctance to allow contractual obligations to be modified or escaped, except in extreme cases, is that unless otherwise stated, the threshold will usually be considered an impossibility of performance. That is, it's physically impossible to deliver on one's contractual obligations. The only, in my experience and looking at all the cases, the only clear exception that's been drawn in the common law is what I call the allocation dilemma. That is where a supplier has 10 contracts to deliver product, but can only, because of force majeure, obtain or source or provide product to limit 50%, let's say, of the total contracted amounts. Courts recognize that there's an allocation dilemma, and even though impossibility of performance for any given contract doesn't exist, the impossibility of satisfying all obligations does qualify as impossibility in terms of force majeure. The last presumption, effectively, that I want to mention is mitigation. The usual assumption is that the mitigation obligation of a party, unless it's defined otherwise, will mean mitigating both the event of force majeure and the impacts on its counterparty. Most of the Canadian and even North American force majeure cases seem to come up in the oil and gas shipping context, and where a pipeline is out of commission for some reason, the shipper can't fix the pipeline, but the shipper can get alternate supply in many cases. And the question is the extent to which that's required. Is there a financial loss limitation on that obligation if there is one? One can, if concerned about mitigation, the first place to loop back to is how performance is defined, and the more specifically performance is defined, for example, supply of product from a particular location, the more likely the mitigation obligation is to be narrowed as well. So I'll turn to the next slide if Eric can, please. I just wanted to mention a couple of related or other doctrines that should probably be in mind for companies that are dealing with counterparties who are unable or having difficulty performing. The first is frustration, and these are all outside of the contractual doctrine of force majeure, but can sometimes be in practical terms, be alternatives to it. Frustration, I've mentioned that ends the contract, and there may be declarations of frustration being considered or having been served as a result of COVID-19 related matters. The second is waiver. That's where a party intentionally relinquishes a contractual right on a permanent basis, and that can't be reclaimed. That needs to be very clear, but there are certainly many cases where there's a dispute about whether a waiver has been granted on a delivery obligation, for example, or a supply of some item, and it's debated whether the innocent party, if I can call it that, accommodating the difficulty of their counterparty results in a waiver or something less. The third is estoppel, and estoppel is often the alternative to waiver. It's a promise of forbearance. That is, you don't have to pay me. Normally, you have to pay me in 30 days, but I'll let it go for 60 days. That is not an intentional relinquishment of a right to be paid within 30 days forevermore, and could be taken back at any time except to the extent the other party has relied on that 60 days to perhaps use the money elsewhere or obtain financing, or there's a million ways that can happen, of course. But a promise of forbearance is essentially voluntary. It can be taken back any time except to the extent the other parties relied on it, put themselves in a different position that makes satisfying the obligation difficult. Finally, the last item is variation of a contract. Again, counterparties that might have some difficulty meeting contractual obligations in the short term because of the current situation we're in, may seek a variation of their contractual obligation. That is really a new agreement and has traditionally required some sort of consideration to flow back. That is, we'll extend payment terms if you will provide us additional security. That would be kind of a classic example of a variation agreement in terms of difficulty meeting obligations in the context we're probably, many of us are probably facing these days. So with that, I will leave you and back to Era, who I think is going to introduce Erica. Thank you.
Thank you, Tom. I have to always remember to unmute myself when I keep talking. That was very interesting. So I'll now turn it over to my colleague in Quebec, Erica, and we will hear from her on force majeure from the Quebec civil law tradition.
Thanks, Era, and thanks for Tom. I think you will see that there's a lot of, in Quebec, in certain circumstances, the notion of force majeure clauses will mirror some of the rules and the principles of interpretation that Tom has raised, but I'll try to piece out the conceptual differences that are in existence in Quebec in terms of how and when force majeure can apply. So the first step, I guess, when we're looking at force majeure in Quebec is obviously we're looking at whether or not your contract has a force majeure clause. And second, what's also very important is to check the governing law clause of your contract. So even if a contract in question doesn't contain a force majeure clause, it's important when conducting this sort of analysis to always check the governing law, because if it happens to be Quebec, there might be additional recourses. And that's because in Quebec, so force majeure exists as a matter of law under the Civil Code of Quebec. So even if a contract does not have a force majeure clause in it, there could be additional recourses that would be available to defaulting parties. That's subject to the possibility of whether or not parties have limited, excluded, or even modified the existing, let's say, the common law regime that would exist under the civil code. So there are two sources of force majeure. There's the contractually stipulated force majeure clause, which is similar to what we have in the common law provinces. And then we have the concept of force majeure or superior force as it's referred to in the civil code. Generally speaking, when we have a force majeure clause in a contract, it's that the contractual clause will prevail. And similar to the other common law provinces, we're going to be looking at principles of contractual interpretation. What do the words of the contract say? What is the level of obligations that need to be met? What kind of relief is provided for the parties? These are going to be provided in the contract. However, if the contract is silent on the question of force majeure, this is where we turn to Article 1470. And so I'm going to discuss a bit what that regime is under Article 1470 moving forward. So you have the article there up on your screen. There's two paragraphs. The first paragraph of Article 1470 speaks to the consequences. So what happens when a party invokes superior force or force majeure? Essentially, they're relieved from their obligations from any liability for their failure to perform. The second paragraph of Article 1470 talks about the conditions that are needed in order to demonstrate the existence of a force majeure event. And in particular, I'm going to be talking a lot about the unforeseeability and irresistibility criterion, and then the external clauses, which has been read by some authors in some cases as being an additional third obligation, whereas for others, it's not necessarily. Before getting into that, one point that is really important to remember is that Article 1470 is not a public order provision. So that means that parties can contractually stipulate a force majeure regime that is completely separate or different to what's in Article 1470. They can also exclude it in its entirety. So that would be in the same case as, for example, if we were subject to in a common law province where there would be no force majeure clause. And if the parties had stipulated that Article 1470 doesn't apply, then there's no recourse to force majeure. But often what we see, as Tom previously mentioned, is that given that force majeure is something that was not really at the forefront of contractual negotiations prior to COVID-19, there's a lot of clauses, and particularly in contracts that, not as complicated contracts that don't refer to force majeure whatsoever, which is where Article 1470 becomes quite relevant, especially in the past few months. So Ara, I'm going to just ask you to switch to the next slide, please. So if we look at the conditions to establish force majeure, those are the ones found at the second paragraph of Article 1470. We're talking about unforeseeability, irresistibility, and external clauses. By and large, when we look at what these entail, they tend to mirror the, I guess, common requirements in the common law provinces. So unforeseeability entails whether a reasonable person that is placed in the same situation could have foreseen the occurrence of the triggering event when the contract was concluded. So an important point here is that a situation that is exceptional is not always necessarily going to be unforeseeable. Another important point is to consider that it always has to be looked at when the actual obligation was contracted for. So if we're putting ourselves in situations for contracts that were, let's say, concluded prior to COVID-19 and prior to the ensuing closures and shutdowns, typically what's occurred over the past few months would likely be seen as unforeseeable. However, as we move forward with the reopening and as we move forward, contracts that are now being concluded today after COVID-19 and after these closures have taken place, there might be arguments to be raised that a contract concluded today, potential future shutdown due to a resurgence of COVID-19 would not necessarily be unforeseeable to a reasonable person today. So it's really important to look at not only what the nature of the underlying triggering event is, but when that contract was concluded. So whether the parties have the benefit of hindsight of the past shutdowns that have already occurred, for example, when looking at that criteria. So the next criteria is irresistibility, and I think that this is where in recent months the crux of the debate is taking place, and similar to in the common law provinces, the test here at Article 1470 is absolute impossibility. So a situation or a triggering event that just makes obligations more difficult or more onerous to perform will not be sufficient in order to meet that threshold to constitute a force majeure event under Article 1470. We're really looking at something that makes performance absolutely impossible. And this is where we really need to look at it's a factual exercise, and this is going to be something that's going to be analyzed on a case-by-case basis based on the underlying nature of the obligations in the contract, as well as the way that businesses conduct their operations. So if we're looking at a supply chain contract, is it possible to get input materials from other sources at a reasonable price? These are the questions that are going to be asked in this context, and I think where the real crux of the debate for where force majeure clauses is going to arise as to whether or not something is really impossible and what the nature of that impossibility is. So the last criteria that I mentioned was external causes, and it's important, I want to frame that it's sort of debated as to whether or not an external cause is a requirement under Article 1470. The essence here is that the event and consequences need to be outside or beyond the control of the affected party. In the context of COVID-19 and forced closures, this isn't really an issue. So the crux of the debate, as I've mentioned, is really focused on that irresistibility criteria. So now if we look at the consequences of a force majeure event, the relief that's provided for under Article 1470 is that the affected party is discharged from any liability arising from the non-performance of its contractual obligations. So as Tom mentioned, we can distinguish between a force majeure event that would make an obligation permanently impossible versus one that would only make something temporarily impossible. So the example of the Opera House burning down, obviously that's something that's permanently impossible. Under Article 1470, in those circumstances, the obligation would be clearly extinguished. However, we can imagine that those actual circumstances would be much more limited. Potentially here, we could think of examples of an event that was scheduled to take place during a government mandated closure. It was absolutely not possible to take place and was not able to reschedule. Here, typically, we would see that the obligation would be extinguished, but those cases are much more rare, and it's much more similar to the doctrine of frustration in the common law. What we see most often, and most of the cases where force majeure is being brought up by the parties are cases where the obligation that is being invoked is only temporarily impossible. So I'm not able to provide by the deadline that's provided for under the contract. And under Article 1470 here, it just provides for the suspension of the obligations until it's able to be done. So you're relieved from any liability for not being able to perform within the contractually stipulated deadline. So in terms of additional requirements, that's what's in the context, that's what's within the Article 1470. I would also note that in Quebec, under Quebec's Civil Code, there is an obligation to mitigate damages as well. So that's found at Article 1479. So while it's not actually within Article 1470, which is the superior force or the force majeure doctrine, all parties that are seeking to be relieved from their obligations in Quebec have an obligation to mitigate their damages. And that's Article 1479, which says a person who is bound to make reparation for an injury is not liable for any aggravation of the injury that the victim could have avoided. So here we're looking at a mitigation of the injury. Typically, that's the provision of the Civil Code. Again, as you mentioned, these are not public order provisions, meaning that parties can include clauses in their contracts that would derogate from that would specify the nature of the mitigation obligations. But if the contract is silent, there still exists such an obligation under the law. So as the next point, I want to sort of look at what the interplay is between Article 1470 and contractual force majeure clauses, because I understand it can sometimes be confusing what should apply when, right? So the golden rule to remember here always at all points in time is that Article 1470 is not a public order provision. So you could fall into any one few circumstances. If we're looking at a contract that's governed by Quebec law, if there is no force majeure clause, and if there is no discussion of force majeure, any sort of exclusion of Article 1470, then it will apply by default and will follow the conditions that are set out there. Often you'll see in contracts, parties will also just import Article 1470 by reference. So they'll note that Article 1470 applies. And then again, we have Article 1470 that applies in the same jurisprudence under there. That said, as is most often the case also when we're dealing with contracts that are applicable across various jurisdictions, you'll have cases where parties draft their own individual force majeure clauses. And when that is the case, it's really important to look at the individual wording of the clause as opposed to Article 1470, since the contractual clause could impose obligations that are, let's say, more onerous, less onerous, or could impose additional requirements. As Tom mentioned in his presentation, one of them is often that force majeure clauses will be coupled with very stringent notice obligations, so contractual notice requirements. And as you'll note, the Civil Code in Quebec, so the civil regime of force majeure does not actually specify any particular notice obligations. However, parties are free to include them in their contract and in most cases, especially in very sophisticated contracts, we see that there are specific notice provisions, as there are in contracts governed by jurisdictions in the common law provinces. So it's really important to verify the content of your contract in order to make sure that whether there are any important notice obligations, as often the consequence will be a failure to, the defaulting party won't be able to have recourse to a force majeure clause if they do not notify in time. So another point that I guess I would want to raise on the notice obligations is that in the context of COVID-19, what we've seen across Canada is that most provinces, most court systems have suspended procedural delays. So if you're working with lawyers, often they'll tell you, don't worry, our procedural delays are currently suspended right now. Filing requirements aren't in effect for the duration of the public health emergency. When looking at force majeure, it's really important to distinguish what are procedural delays, so procedural filing requirements versus contractual requirements. In Quebec and elsewhere in Canada, these are contractual requirements. So the suspension of procedural delays before the courts and whatnot is not going to entail the suspension of contractual delays to provide notice. So if there's a possibility of wanting to have recourse to a force majeure provision, it's important to keep that in mind, that just because, let's say, you're dealing with a litigious file and procedurally delays have been suspended, that's not going to apply by default to the contractual notice requirements. So to just keep that in mind as well. I guess the last point that I wanted to note that's important when looking at force majeure clauses in Quebec is due to the fact that we have this separate legal regime of force majeure in addition to the contractual regime. What we see sometimes is that where force majeure clauses require interpretation, so where there is some sort of ambiguity in terms of the drafting of the languages, have on occasion have had recourse to how Article 1470, so the legal regime of force majeure, has been interpreted in the past. So when interpreting a contract, when we're looking at a contractual clause, the guiding principles are going to be that if that clause is clear, if it's unambiguous, doesn't require interpretation, the courts will apply it. So there won't be any recourse to principles of interpretation under Article 1470. If and I know Tom mentioned it's rare that we have cases that a pandemic or an epidemic are listed in that sort of list, but let's say we do have a case like that. This wouldn't necessarily be a situation where we need to interpret what is meant by a pandemic because it's very clear that it's on that list of items. However, if we're now moving into the sort of catch-all, the basket clause of any other event that is outside the control or the foresight of the party, that's often something that requires interpretation. Here, courts might look to guidance as to how Article 1470 has been interpreted in the past in order to make that determination. So it's important to keep oneself informed a bit as to how it's been done, because that could have an impact on a force majeure clause that is drafted perhaps more generally and that would require a certain degree of interpretation. So I think that's sort of it in terms of force majeure in Quebec. Apart from that, if we're dealing with a force majeure clause in a contract that's governed by Quebec law, similar principles of interpretation would apply in the common law provinces, but always to keep that in mind that that's sort of situated against the backdrop of what Article 1470 and how the courts have interpreted that provision.
Thank you, Erica. That was a very interesting and a particularly important point about the notice provisions not being subject to the statutory tolling of procedural and limitation periods. That's an excellent point, and certainly very, very important in the context of invoking something as extraordinary as force majeure. So briefly, one of the issues in Canadian contractual interpretation law that's come up in the cannabis industry is invoking force majeure or frustration of contract and related doctrines in the context of a letter of intent or a memorandum of understanding. I'd therefore like to speak to you a little bit about agreements that are subject to more formal contracts and the unique issues that they may present. As a general principle, An agreement to agree is, of course, not an enforceable contract. Having said that, a binding and enforceable contract can still exist even though some additional formality is contemplated by the parties. So a letter of intent or a memorandum of understanding will, as a matter of law, create a valid and enforceable contract as long as it contains the, quote, essential terms of an agreement. So where the parties agree on all the essential provisions to be incorporated into a formal contract, with the intention that their agreement is binding, they will have fulfilled the prerequisites for the formation of a contract. The fact that a formal written document to the same effect is to be later prepared and executed does not alter the binding validity of the original contract. The court will therefore analyze the parties' letter of intent or memorandum of understanding to determine whether all essential terms have been agreed upon. Price, for example, is almost always regarded as an essential term. The lack of an agreement on price will typically make an agreement unenforceable. Context is essential to the analysis that's brought to bear on a letter of intent or a memorandum of understanding. Naturally, the nature of the transaction is always essential for determining what terms are, quote, essential. If the document expressly states that the agreement is, quote, subject to approval by the board of directors, end quote, the acceptance of such a document will not create an enforceable contract. By contrast, the absence of traditional language in a letter of intent or a memorandum of understanding showing the intention to make it conditional on later agreement, such as use of the words subject to contract or subject to the parties reaching further agreement, shows that the parties did not leave essential terms for another day. The court will look to the parties' subsequent conduct when deciding whether a letter of intent or a memorandum of understanding created an enforceable contract. If the parties carried on business as though they had a binding contract, then the court will likely hold them to their bargain. There are circumstances, for example, where a letter of intent is entered into with the classic provision saying subject to contract. So ordinarily, such a letter of intent would not create an enforceable arrangement. However, where the parties continue their relationship for months down the line, then the court will look at that subsequent conduct as evidence of a binding agreement being reached, notwithstanding the term subject to the phrase subject to contract. So what does this all mean for cannabis companies who face unique operational challenges, such as corporate consolidation, supply chain challenges, and adjusting to a complex regulatory regime? Well, if a letter of intent or a memorandum of understanding is only intended to serve as a jumping-off point between the parties, then it should expressly say so by using language like subject to contract or subject to negotiation. If, however, the desire is to make an enforceable contract, then the parties should be careful to ensure that the essential terms of the agreement are adequately captured and captured with sufficient certainty. The letter of intent or memorandum of understanding should always include a force majeure clause that reflects the realities of modern society. As we heard from Tom, before the COVID-19 pandemic, force majeure clauses were often overlooked, boilerplate, and underappreciated. As the cannabis industry was facing challenges before the pandemic, Canadian courts would likely be very careful to review the underlying context in which force majeure is declared. Although the COVID-19 pandemic may indeed constitute an act of God or other force majeure event, the court will be careful to assess whether the party invoking a force majeure clause could still perform its obligations under the contract. And this is all the more important as the cannabis industry was deemed to be an essential service in several provinces. So I'd like to take this time now to ask Tom and Erica to provide us with some tips to remember moving forward. And before I do so, Tom, I'll start with mine. So first, a letter of intent or memorandum of understanding will create an enforceable contract where it contains the essential terms of the bargain, even though some further formality is contemplated. Second, where your LOI or MOU is intended to create enforceable arrangements, don't sacrifice brevity for ensuring that it includes a force majeure clause that reflects the realities of living in the 21st century. Failing which, while you may not have a contractual remedy, you'd have to resort to the more uncertain and narrow doctrine of frustration of contract to excuse non-performance.
It looks like Erica is still muted, so I will deliver the next couple, even though I credit Erica with drafting them and I couldn't improve or revise them in any way that would make them better. So takeaways, common law, we've come up with. One is determining whether a party can be relieved from performance of its obligations due to force majeure is something that has to be analyzed on a case-by-case basis. Every contract is different in terms of its language, in terms of its surrounding circumstances and what the parties would have assumed and understood at the time they were contracting. And each incident of non-performance is also difficult and unique to assess. Next, parties should assess and document on an ongoing basis the costs and delay impacts of COVID-19 on the performance of their contractual obligations, and take care to mitigate effects when they can. This is probably generally good business practice, but particularly important if there's been a force majeure declaration by you or by a counterparty. And I'll turn it over to Erica there to add some color to that and also to put it in a Quebec lens.
Yeah, so from the Quebec angle, I guess we always need to keep in mind, first of all, the first step is your contract governed by Quebec law. It's the first starting off point. And if we are there, to verify whether you do have a force majeure clause in your contract, and if so, what sort of relief is provided under that clause, keeping in mind that a clause in a contract could have very different relief than what's provided for under the civil code. So parties could be approaching this from very different standpoints. Second point, obviously, to keep in mind is that if there is no force majeure clause in your contract, but your contract is governed by Quebec law, that's not the end of the line, because we do have the safety net of Article 1470. Well, I guess I say safety net depending on what perspective we're looking at it from. But Article 1470 would apply by default, and there could still be an entitlement to relief under there. So to always keep that in mind if you're dealing with a situation where the contract is governed by Quebec law.
Thank you, Erica and Tom. That was very helpful. To close it out here, we have some time for some questions. So I'd like to kick things off and ask this directed towards both of you. And I'd be interested in common tips to employ when drafting a force majeure clause. And maybe as part of that, any kind of common mistakes that you see when you're reviewing these provisions after the fact.
Eric, if it's okay, Erica, I'll take a first stab at that. In terms of tips and common mistakes, I think it's really the same question in many ways, where parties tend to get themselves into trouble, and by that I mean to wind up with results or uncertainties that they were not intending, really tend to seem to fall into three kind of categories. The first is where they haven't taken enough care to ensure consistency between interrelated contracts. If one is wherever one is in the supply chain, you want an upstream force majeure declaration to allow you to equally declare downstream and vice versa. So that is certainly something of ultimate importance. The more complex and the more sizable the supply chain one is within becomes. Second, a focus on what's included and what's not included as a triggering event for force majeure. Obviously, we've mentioned a pandemic as one item that can be included, but it's maybe important in some cases to exclude items too. For example, lack of funds. One doesn't want to give the other side an opportunity to declare force majeure simply because the economy has been harsh to them or they've been unable to source funds for reasons that you have no control over. Another aspect of that would be acts or omissions of third parties. Those can, in certain cases, be specified as either excluded from or included within a force majeure triggering event description. The third, so the first, ensure consistency with other contracts. Second is focus on what's included and what's excluded. And the third would be consider what limits might be appropriate to mitigation obligations. I mentioned the example in the standard form natural gas shipping agreements. One of them has a material economic impact limitation on that obligation. So the limits might be financial, they might be operational, in that the obligation to obtain an alternate supply might be excluded or specifically included. A sort of an aspect of that that has to be looked at too, if you're concerned about mitigation obligations, is how performance is defined. And I think I mentioned that earlier. Is it defined in a very specific way? Because the more specifically performance is defined, the narrower are the likely mitigation obligations in terms of alternative modes of performance. So those would be the three tips. Erica, you may have something to add.
Thank you, Tom. We may have lost Erica. One more question that has come up, however, that I'd be interested in your views, Tom, is you mentioned foreseeability and the notion that a court will look at the clause and see whether the event that is being declared as a force majeure whether it was reasonably contemplated and therefore could have been addressed by the parties such that a force majeure event has not in fact occurred. How do you think courts will address contracts made by parties during this interim period where we knew there was a pandemic or a outbreak in Southeast Asia, but it hadn't already been declared a global pandemic, or the implications weren't felt by Canadian companies yet? Although certainly COVID was aware, it was in the news, and it ought to have been on people's radar.
That may be a difficult question, Aaron. My own supposition is that courts will tend to be pretty sympathetic to COVID-19 declarations, assuming that the other requirements of force majeure are met. That is, did it really prevent performance? Foreseeability is, as I said, has been a troublesome concept in terms of force majeure. Certainly, the pandemic may have been foreseen as arriving on our shores, long before it did, but is it the pandemic or is it the responses to the pandemic that are the real triggering event here? That is, are they the government orders or government restrictions, which are often included in a description as well? Generally, certainly my feel for it is that there'll probably be quite a bit of sympathy for the declared party in that case. And foreseeability of a pandemic doesn't necessarily mean that its impacts are foreseen.
Quite right. Thank you, Tom. So that we've run out of time. I want to thank Tom and Erica for their outstanding presentations. And subject to any further questions we might have, this concludes our seminar for this afternoon. And I would like to thank all of our clients for joining us today.
Thank you, everyone. Thank you, Era.
Thank you, Rin. Thanks, Sarah.